Most people assume a DUI requires a car or truck. In California, the law is broader than that. Vehicle Code 23152 makes it illegal to drive any motor vehicle while impaired, and a golf cart qualifies as a motor vehicle under California law. That means the same rules that apply on the freeway can apply on a golf cart path or a public road. A key question is where you were driving. If the golf cart was on a private course that is entirely closed to the public, prosecution under the standard DUI statute becomes much harder. But the moment a cart crosses onto a public road, a parking lot open to the public, or any place the public can access, you are in DUI territory. Many golf communities have roads that connect holes, and those roads can be considered public ways. If an officer stops you on a golf cart and suspects impairment, the arrest process looks almost identical to a standard DUI stop. They can ask you to perform field sobriety tests, and California's implied consent law means that once you are lawfully arrested, you are required to take a chemical test, either breath or blood. Refusing that test brings automatic license consequences on top of any criminal charges. A first offense DUI conviction, even on a golf cart, carries the same baseline penalties as any other first DUI in California. That includes a base fine of several $100s that mandatory penalty assessments multiply several times over, up to 6 months in county jail, probation typically lasting 3 years, DUI school, and a license suspension. These are not minor consequences, and they follow you on your record. A golf cart DUI conviction posts to your California driving record the same way any DUI does. Your public driving record, the one insurers and employers typically see, reflects the conviction for 10 years. However, the DMV keeps a permanent internal record, and that entry never goes away. If you face another DUI arrest in the future, even decades later, this conviction can count as a prior offense and increase the penalties significantly. Because golf cart DUIs are less common, there are sometimes factual and legal questions that do not arise in typical cases. Was the location truly a public way? Was the stop lawful? Was the chemical test administered correctly under Title 17 of the California Code of Regulations, which sets the standards for how breath and blood tests must be conducted? Results vary in every case, and there is no promised result, but these are the kinds of questions a defense attorney examines. Understanding the law is the first step to making informed decisions about your situation. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.